Party series. Today, we're looking at a situation that sounds like it could come straight out of a Hallmark movie. An heir being listed as deceased in the official probate filing, even though he is very much alive and even maybe possibly watching this stream right now. This Alabama intestate estate, meaning no will, involves a father who passed away last summer, a half-sister who opened probate, and a family tree with adopted siblings, estranged relationships, and some serious paperwork errors. We're keeping every detail fully anonymized for privacy. Anonymized, but the facts are real and they show exactly why heirs need to act quickly when probate opens. Quick disclaimer, as always, I am not your attorney. This is not legal advice. This is for educational purposes only. Most likely, I'm not even licensed in your state. And so if you need legal advice, please consult with an attorney licensed in your state. All right. And of course, results may vary. All right, let's dive in. So here's the case background. The decedent passed away in August 2025. His wife, our potential client's stepmother, had passed just a couple weeks earlier. He died without a will, intestate. So in Alabama's intestate succession laws apply here, which means everything goes equally to his descendants, his children. Probate was opened on March 10th, 2026 by one of the decedent's daughters from his later marriage. In the filing, she listed the caller, we'll call him Louis, as deceased. His twin sister, who actually is deceased, correctly marked as such, and then several other biological and adopted siblings either omitted or listed with unknown addresses. Louis only learned about his father's death months later. Once he started digging, he found the probate notice, pulled the court paperwork, and immediately contacted the clerk to confirm he's alive. He even sent a notarized letter assessing his claim as an heir. The estate includes a house valued at approximately $253,000, appears to be paid off, a couple of older vehicles, a trailer, and some small bank accounts and debts. The core problem, what's the issue here? Alabama law requires that the personal representative to make a reasonable effort to identify and notify all heirs. Listing a child as deceased and leaving other siblings off or hard to find or locate creates real problems, potentially personal liability for the personal representative here. Even though the half-sister may have been acting on incomplete or outdated information from the father, he was estranged from some of his kids, the filing still needs to be corrected. Here's some additional complications here. One brother was later readopted and has a different name. Some siblings were adopted by this decedent years earlier from the mother's previous marriage. Their status as heirs still needs clear documentation. And personal property inside the house, furniture, personal belongings, wasn't itemized on the initial inventory. Courts usually only require high-value assets, but heirs still have heirs still have rights to those items. Small debts and creditors are listed, but the real picture often becomes clear once the personal representative starts gathering bank records and final bills. The caller's goal is simple: a clean, uncontested process so every rightful heir gets their equal share. No drama, no fighting. So, a couple of the red flags we're seeing here. The living heir is listed as deceased, other siblings omitted or hard to locate, incomplete heir list in the intestate estate, and then personal property not addressed. Let's move on to our client's questions in our discussion and what we could possibly do for him. He had some very practical questions we hear all the time in these missing or mislisted heir cases. Number one, should I contact my siblings right away? We advise that since they're already identified on the paperwork, even if the addresses are unknown or incorrect, the court process will eventually notify them. Reaching out personally can help coordinate, but it's smart to get legal guidance first so everyone understands their rights. Next question. Is the half-sister's stepbrother serving as a personal representative a problem? Not automatically. Alabama requires the personal representative to live in state and meet basic qualifications. But when family relationships are strained, or estranged, having an independent watchdog in the process protects everyone's interest. What about the furniture and personal items? Courts focus on titled assets and high value items for the inventory, but heirs can request an estate sale or division of the contents later. The key is making sure nothing disappears before that happens. Louis' bigger concern, he doesn't even know what's at stake before he spends money on an attorney. We talked him through the house value and other assets. Even after death, there's meaningful money to protect. So here's our solution and what happens next. Step in as the heir's representative or watchdog to correct the probate filing and confirm all living heirs. Request proper notice and an accurate heir list so the process moves forward cleanly. Number 3, monitor the inventory, asset sale, and distribution to ensure everything is handled fairly and according to Alabama law. And finally, keep things uncontested where possible. Our presence alone often keeps everyone honest. And so what are the key takeaways here? 3 big takeaways. Number 1, always pull the probate file yourself. Even a quick online search or a call to a clerk can reveal huge errors like a living heir being listed as deceased. Number 2, in intestate estates where there's no will, every child, biologically or legally adopted, has rights. Incomplete heir lists delay everything and risk unfair distribution. And finally, getting an attorney involved early as a watchdog is often cheaper and smoother than waiting for problems to explode. And finally, a pro tip: if you're an heir and you see probate open, send a notarized claim letter to the court immediately and consider having counsel review the filings. Don't assume everything is being handled perfectly. So that's today's real anonymized case study. Who's actually in heir situations come up more often than you think, especially when estranged family members and second marriages. If you've ever been surprised by a probate notice or think you might be an heir to an estate, drop your questions in the chat. I'll answer live or follow up after the stream. Tomorrow, we're doing estate planning frequently asked questions. Hit follow, subscribe across every platform so you get notified. And if, of course, you have a estate planning question, please let us know and I'll include it in tomorrow's live stream. Final reminder, this is not legal advice. It's for educational purposes only. Always work with an attorney licensed in your estate. This has been Bobby Sawyer. Thanks for joining us.